I'm Jonathan Mason.
And I'm Sonya Madison.
And welcome to Law Unfiltered, your weekly, what do we call this?
I don't know, I guess.
Law magazine is a law.
Catch up.
It's an electronic magazine. I don't know what it is. We just like to talk about legal issues from, different sides and explore, below the surface a little bit. And Sonya, you love these Supreme Court cases.
I do.
And sometimes we battle over whether to talk about them or not, and you always win. But so recently the Supreme Court, well, they didn't hear. I guess they were deciding whether to hear the voting case from North Carolina. You can just, I guess, talk a little bit about the case and then what happened with the Supreme Court.
Right. Well, as probably your listeners or our listeners know, the Supreme Court back in, 2013 looked at the Voting Rights Act. And essentially they decided that certain provisions of the act were no longer relevant anymore, particularly the provision requiring certain southern states to report to the Department of Justice if they want to change any type of voting election laws before they could actually enact those laws. And so the Supreme Court decided that, well, this is outdated now. The reason that it was decided back in 1965 was because of the issues going on. Those aren't prevalent issues now. And so we're not going to mandate all these states to have to seek Department of Justice approval before they enact certain election laws. So after that happened, North Carolina and some other states like, I want to say Florida as well as Wisconsin, decided to go ahead and start putting into place new election laws. And what North Carolina said, well, we're going to make it so that not only when you register to vote, do you have to present a voter ID or photo ID. When you come to cast your vote, you have to present a photo ID, which was not something that was originally required. They also said that, in addition to having to, and I was drawing a blank, but there were at least two other provisions also that they required. And so then a lot of people said, wait a minute, hold on. You have distinctly done this to try to take out a large proportion of African American voters. And so we call that discrimination, therefore unconstitutional. They took it up to a federal judge. The federal judge said, no, it's fine. We don't feel like there's any hindrance on African Americans being able to get a photo ID.
I'm sorry, I have to laugh because I'm not going to say it on camera.
What?
I'm just laughing because I know the federal judge who you're talking about.
Yeah. You can hear him kind of saying it like that, am I?
No, not in that sense.
Okay.
Like I understood the ruling because I know him. Just the fact that I know him. It's just,
right.
Yeah.
Well, the federal judge said, no, I don't see any problem with African Americans being able to have an ID. It shouldn't disproportionately impact. And he even goes on to say, in fact, during the next election, they came out in an even higher, share than before. So clearly it's not a problem. Well, then again.
So what's wrong with that?
What's wrong with that argument?
Yeah.
Well, that's where it goes to the appellate court, and that's the question that even I want to get your feedback on, is whether the standard should be if you intentionally did something for the purpose of discriminating against a group of individuals, regardless of whether that effect happened. If your whole motive was to discriminate, then should that be sufficient? And that's what the appellate court said was, listen, and they quote said, federal judge missed the forest for the trees. They went back after this voting rights decision that the Supreme Court came down with and found ways to try to target, at least according to what the appellate court is saying, target African American voters. And it's true, at least in their research, they discovered that, first of all, with the photo ID, they limited to certain photo IDs. Like they said, it couldn't be an expired driver license. Well, a lot of people who have driver licenses, particularly ones that are active, are mostly majority. Also, one thing was they said this early voting. You can have this week before the actual voting period. They tried to take that out. Well, the judge said, well, you in your research saw that mostly African Americans are voting a week early, particularly on that Sunday instead of that Tuesday. And so if you take that out, you're targeting African Americans. And so that's why they made their decision, because they decided it's not about the actual effect, it's about your intent.
So let me ask you a question, like who does that research in a case like that? Like who has those facts about who's voting and when, and that type of information. And wouldn't that information have been available to the district court judge as well?
Right. Well, according to the appellate court, the Fourth Circuit Court of Appeals, they're saying the GOP lawmakers had that information. They did the research, and because they used that information, knowing how it was going to affect certain groups of people, then the fact that they ignored that effect, or the fact that they used that and proceeded with it, it was a direct target. Now, of course, it's going to come out, when it comes to the federal judge and the Court of Appeals, because discovery period is that opportunity to be able to get all this research that the other side has to see if there is that intent. Did you, kind of like we talked about in that last case, do you have that smoking gun where someone is putting the letter B around people's names, and it can only mean that you're using that race to make some type of decision.
What was the basis for the law? I mean, was there allegations that fraud in voting, or like why did the state decide that they needed to change the law?
Well, that's what they're saying. They're saying, listen, we want to protect people from fraud. It's one thing, when you register to show the ID, but if they don't have to show their ID when they're casting the ballot, then people can take or use other people's identifications and not have to show proof that this is in fact who I am. And so, and the federal judge felt like, hey, because the standard, typically if there is a government interest, then that government entity has to show that whatever your reasoning or whatever your method to fulfill that government interest is tied to, that actual fulfillment. And so in this case, the Court of Appeals is saying, well, hold on, you haven't showed that you've ever arrested someone for fraud based on the previous legislation, so you haven't even showed there's an issue here, and then you still haven't showed that by enacting this, you've alleviated a problem that you've never even established was a problem. So yeah.
Okay. All right.
But again, that's what the appellate court is saying. Now, the Supreme Court decided not to do it, but it was a 4-4 split, and so I'd imagine, of course, you're going to have Justice Thomas, you're going to have Justice Roberts, you're going to have those conservative justices saying, hey, we want to look at this and potentially strike down what the appellate court is saying. And then you have the other 4 justices, Justice Sotomayor, Justice Ginsburg, and so on, that are saying, no, let's not look at it, let's keep it as it is. And that's why the split came.
So as of now, with the law having been struck down, basically, what do you need to vote in North Carolina?
In North Carolina?
Yeah.
Nothing. It's the same. As long as you've registered within, whatever period. And I think they even have a provision where they permit you to register and vote on the same day. And that was one thing they wanted to strike down as well, that opportunity to vote and register on that same day. So that still remains. There is a day where people can come in and register as well as cast their ballot on the same day. They're also able to not have to bring their identification on the day of voting. And then again, they're able to vote early if they want to within the specified already used time. So what is going to be interesting then, because I kind of was thinking about Georgia, and every time I go, I'm asked to show my ID. And so I'm curious as to if, North Carolina looked at other states or tried to use that argument that, hey, other states are doing this. It's clearly not intentional discrimination, as it hasn't been struck down, or at least the Department of Justice didn't tell them they couldn't do it when they had the opportunity to do so prior to 2013. I wonder if that would have played any factor. Now, we don't have the register and cast your ballot on the same day.
Well, yeah. And also, I guess we're not eliminating early voting and other things that were found to have a discriminatory intent as well. But yeah, I've always had to show my photo ID whenever I go vote. So.
But I'm also thinking, I can hear it in my head Justice Thomas saying, it's not about an intent to discriminate, it's about, is there actual discrimination? Or just some of the conservatives saying that, because that's to me the argument they were making with the Voter Rights Act. It wasn't about whether these states are putting these laws in place to intentionally discriminate. It's about the application today. Is it warranting the outcome that it had in the past? So, their decision seemed to be more outcome oriented than intent. So,
well, intent, I know in like a criminal context or even in intentional tort context, I mean, intent is generally very difficult to prove. And that's when you're talking about the intent of one individual. And I guess in this case, you're talking about the intent of a body,
Right.
a legislative body. So, but I guess you just have to look at all the facts and the evidence and say, hey, they knew that, a lot of African Americans vote early, or maybe a lot of African Americans don't have the required ID, or whatever the evidence showed. But it's interesting.
Which I'm sure, in this day and age, you have to look at it. If I remember we talked about this with the jury Vordaer incident. You do have to look at whether or not your action is going to have a disparate impact. It is what it is. And I don't have an issue with you having to look at it, particularly if in this case, you had a perfectly fine election law. You're not showing that there was an issue of fraud. So then it's like, well, why now? Why are you changing it now just because you can? And if you did do research prior, then I'm going to assume that your research is why you're changing it. So then let's look at the research. And if it's clear that, okay, you at least saw the disproportionate impact a certain group is going to have, well, did you either decide, well, it doesn't matter as long as, they're still capable, Yeah. And again, I guess going to, legal standard, does it matter as long as the actual outcome is still equitable? So, that's going to be an interesting, if it ever comes back, because again, right now we have an 8-justice court. So it could come back if Trump appoints someone to the Supreme Court, then it is definitely, I can see it coming back up to the Supreme Court and going, North Carolina's way. And of course, if Hillary appoints someone, it might go.
What do you mean come back? Like, is it not resolved now because it was a split, or?
Yeah, it's not resolved. So the Supreme Court did make a decision.
So once another member is appointed, you mean it could be brought back?
It could be brought back. And there are other states that have also contested their lower court's decision not to allow them to enact new laws, or you have people like the civil rights activists and various other civil rights groups that failed, and so then are also appealing in hopes that the Supreme Court will strike it down.
Well, obviously voting is a hot topic right now.
Particularly given who we're voting for. I think this election in general is...
I'm just ready for it to be over. I can't even take 5 seconds of CNN right now, because that's all, every day, that's all they talk about is, Trump visits Mexico. Hillary responds and says it's a publicity. I can't take it. Just want to, okay, if they're going to debate, okay, fine, let's have a debate, which they may or may not have, but
oh, you don't think that helps?
All this back and forth is just drives me crazy. I can't take it. It turns me off from politics.
Well,
really.
it was interesting that he went to Mexico, and of course all the comedians are like, that's when you build the wall, when he actually goes to Mexico. But I found it interesting that he claims, oh, we didn't talk about who's going to pay for this wall, whereas the Mexico's president saying, no, I told him we're not paying for this wall. Yeah. But I'm also just more intrigued by the people voting for him than I am.
Yeah.
Him, but we don't want to be too biased on this show, so.
Biased?
I know.
Us?
Good luck to both candidates.
All right. We'll see you next time on Law Unfiltered.